Hey, and welcome to Cannabis Quick Hits, Green Spoon Martyr's new webinar providing critical information regarding the various different topics, everywhere from our topic today, employment law in the cannabis industry, all the way through to, I think we're going to go do some fun stuff and talk about terpenes or something like that as well. So we are really, really excited about this series, and I'm really, really excited to have with me today Michael Freeman, a partner here in our Denver office. Michael is just a great guy and an awesome attorney. He and I have a lot of fun together, I have to admit. Michael focuses on employment law and commercial litigation, and he is just great and has had a lot of experience in both of those areas in the cannabis industry and elsewhere. Like most of the lawyers here at Green Spoon Martyr, he brings a ton of talent in coming from other industries in the general practice area into the cannabis industry to help out our cannabis clients. And I'm super excited about our topic today, employment law. Mike, before we get into it though, why don't you tell us a little bit about how great you are?
Well, I could go on for hours telling about how great I am, but I know we have some limited time, so I will try not to go on too long. Appreciate you having me. I'm really excited to talk to you. A little bit about me. I've been doing the attorney thing for 20 some odd years now. As you said, my practice right now is pretty mixed between employment and commercial litigation. Love to be in the courtroom, love to be advocating and litigating on behalf of my clients. I have somewhat of a unique background, military background, still in the Air Force. Been doing that for over 20 years as well. Was also in-house for about 10 years. So I think I bring somewhat of a unique perspective when it comes to advising our clients and being able to put myself in their shoes and knowing some of the nuances that exist in the corporate and operation space.
For sure, and I think you have been really, really helpful for a number of our cannabis clients and non-cannabis clients in their employment law area and helping them with their handbooks and with specific employee issues and understanding an area of the law that is largely evolving, right? We've got a number of new kind of employment laws out there in different kind of states. Mike, why don't we start off a little bit with kind of what we're seeing in like developments in the employment law world. And I think here in Colorado specifically, we have a new law. Is it a equal pay, equal work law or something like that? Why don't you clue us in on that stuff?
Yeah, so effective the first of this year, as you said, there's a new law in Colorado called the Colorado Equal Pay, Equal Work Act. And the focus of that was to make sure that employers are paying their female employees similarly or equally to their male employees. And there's two specific components to that law that I want to flag for our listeners out there. Number one is the legislation allows and encourages employers or companies to do an internal audit to make sure that they are in fact paying their employees fairly. And if you do this audit and are ever sued or anybody brings an action against you, your litigation or your liability, I should say, is capped. And you have some incentive to actually conduct this audit. And if people out there have questions on how to do that, we've done a ton of these and happy to provide some guidance there. The second part that I wanted to flag and is deals with job postings. And it's somewhat unique in that if you are posting a job for a promotion position internally or posting for a position externally, there are certain requirements that employers have to follow in order to be compliant with this new law. And I know a lot of my clients out there, this is new to them. And even if you're not in Colorado per se, you're headquartered here, if you have any Colorado employees, this law applies to you. And even if you are, if your people are working remote and a job application or a position application goes out there and they're allowing Colorado residents to apply for that job, arguably this law would apply as well. So you want to make sure that you know what the law is and you know what your posting requirements are when it comes to making sure you're compliant with this law, because you don't want to go sideways with it. It's relatively new, so we haven't seen a ton of litigation based on this law yet, but I'm anticipating that within the next 6 to 12 months, we're going to see an uptick in cases filed based on violations of this new law.
Certainly some really important stuff for employers to know and to get out in front of and prevent problems coming up down the future when this law, we have to assume, is going to be enforced. What is there, Mike? I don't want our listeners to think that small businesses don't need to worry about employment law matters. Certainly that's not true. But is there a size requirement for some of these new rules, or is that apply to all employers?
If you have any operations or at least one employee who is in Colorado, or you are sending out applications and you're looking for Colorado residents to apply for positions, the law will apply to you.
Wow, that's really interesting. There are a lot of very skilled professionals and workers in the Colorado cannabis industry that are, moving to work for companies in other states. Would it apply to something like that?
It would, as long as the employee has standing to bring a case forward. So if they're in Colorado or they have a Colorado nexus, then arguably they have the ability to bring some type of violation under this new law. And employers should be very mindful of not running afoul when it comes to the requirements under the law.
Some fine details there, I got to say. Mike, I have been hearing a lot about how the sort of power struggle between employers and employees has sort of shifted a bit through COVID, and employees are getting a lot more sort of ability to negotiate and are demanding more from their employers. It seems to me that it's the sort of employee relationships is a big part of what we're talking about today in the labor law world. Are there some things that we do to help in that process? Is that if I have an employee relationship problem, what should I do? Who should I call?
Great question, Nick. And I think you're dead on. And especially with a lot of employers allowing their employees to return to work, I'm expecting to see a lot of employee relations issues over the next few months, when employees have been used to, in the past, since this pandemic started, working from home, working remotely, having a little more flexibility, not having supervisors looking over their shoulders, making sure they're doing what they're supposed to be doing. I'm anticipating a decent amount of pushback and having some of those employee relations issues surfacing more than we have seen over the past 12 to 18 months. So if that happens, and this is going to depend on what your setup is like, but I think, and you know this better than anybody else, the cannabis world, a lot of our clients are relatively small or smaller, and they may not have that internal infrastructure, the HR department or in-house legal counsel to run some of these ideas by. So I'm always a big advocate of, if you have an issue, get out in front of it, have the 5 to 10 to 15 minute conversation with somebody like me or somebody in HR, just to have a sounding board. I want to take this action. Do you think that you see any issues with it or any red flags? What can I say to my employee without stepping into something that I don't want to step into? How do I word this? Can I give somebody a performance improvement plan for not meeting these certain criteria? Can I give somebody a written warning? Can I fire somebody? What do I do? And making sure you have that conversation ahead of time, in my opinion, goes a long way. I'm always a big fan of having that initial discussion at the onset. And I think in the long run, you're going to save a lot of time and money, as opposed to you didn't have that conversation, things went south, and then you're trying to dig yourself out from a pretty big hole.
15, 20 minutes with Mike can save a business a lot of money when they're dealing with these things. Super important. And we do a lot of that. One of those thoughts about how lawyers just want to, charge a lot of money or whatever. We want to help people is what we do. And Mike and I both talk to people all the time and help them understand whether they really need to hire a lawyer or not, and give them a straight talk on that. And I think that we both pride ourselves on helping people understand that. Mike, I got one of these old employee handbooks at home. What is that thing? Should I be looking at that? Is that important for me as an employee and as an employer? Is that something I should be updating regularly? Is it set in stone? When do I need that? Do I need that when I have one employee? Do I need that when I have 10 employees? Help me understand some of the requirements around having an actual manual of some sort.
Yeah, another great question, Nick. And I think we see that more and more in the cannabis space, where the initial startup was 3 to 4 employees, and everybody knew the owners and the people who put the thing in place. And then the next thing you know, fast forward 6 months, and you have 50 to 100 employees, and half of them you've never really met before or don't really know that well.
Yeah.
And those are the ones where they wish they had a handbook. So to answer your question, employees should definitely be reading the handbook and know what the policies and practices are. And I would certainly encourage employers, to the extent that you don't have one, put one in place. If we're having those conversations that we just talked about, many times I'm going to ask the question, well, what does your policy say? Do you have a policy on this particular issue? When somebody shows up to work under the influence of alcohol or drugs, do we have a reasonable suspicion policy as to when and how we can test them? If somebody is on some type of extended leave and they don't show up for work, or they don't call in time, does that give us the right under the policy to voluntarily separate them from employment? Having those in place would go a long way and make life much easier. And to your point too, the laws are changing all the time with COVID out there, and with other this Colorado Equal Pay, Equal Work Act. There's a lot of moving parts, both in Colorado and across the country. And you want to make sure that the policies that you have in place are actually current and up to date. So I usually advise my clients that if they're not getting their handbook checked, and you're checked out by an attorney or somebody in HR every 12 to 18 months, and they're probably doing themselves a disservice. And I would guarantee that at least some of the policies that they have in there are not accurate or not up to date and could be unlawful.
And I guess it comes down to, if you have a policy, your employees need to know about it. And if you're an employer and it's in the employee manual, you can point to it. And that's really strong for an employer to be able to do, I would imagine.
Absolutely. And if you have that employee handbook, you want to make sure that your employees have access to it. You want to make sure that when they're onboarding, there's some type of acknowledgement that they have access to it, that they've had the ability to read it, and hopefully they have read it, and that they understand it. And if you don't have that initial acknowledgement up front, you want to get it from the employee and make it a condition of employment before they start work, that they are going to abide by your policies, and they don't have the right to do whatever they want to do. There is some structure, some guidelines, some reference as to how they can operate on a day-to-day basis, and it's there for your protection too, both the employee and the employer. That these laws and the practices and policies are there to make sure that people are safe, people are doing their job efficiently and effectively, and that there won't be any issues. And if there is a question, both the employer and the employee can turn to the employee handbook and say, "Oh, here's the answer to our question, and we know what we should be doing on a going forward basis."
What I'm hearing here is, get your act right and get things in place before they come up. When things do come up, call your lawyer or your HR person. And isn't the critical part about all of that is when a problem comes up, the real issue is, what did the employer do after that, right? Isn't that the real thing about properly managing the problem once the employer really knows about it? And as I recall, that's a big part of doing the right thing.
100%. And certainly the action leading up to the event is going to be scrutinized as well. But more times than not, I've found, especially from a employee morale, employee happiness relations perspective, if the employer communicates with the employee, gives the employee a chance to be heard, has some type of discussion with him or her, and put stuff out there as to, okay, I understand that this is an issue. Here is how we want to correct it. Here is how we want to address it. And you come up with a collaborative plan that works for both the employer and the employee. In my opinion, 9 times out of 10, things will de-escalate there, and the employee will go back to being happy and productive for you. But the worst thing you could do is ignore it or tell the employee that they're just dead wrong and go back to work. And even if you are correct as an employer, you're going to be left with a disgruntled employee who maybe not this time is going to file something or go after you, but they're not going to be happy, and either they're not going to be performing their job as well as you want them to, or they're not going to be vested in the company like you want them to, or if something happens in the future, there's a better likelihood that they're going to come after you for some type of claim of and insert whatever it is, but they're not going to be they're not going to bend over backwards to try to make you as the employer happy.
Mike, great information. Mike, what's your email real quick? I think our listeners need to give you a call, or give us that too.
Well, the email is Michael, Michael .Freeman, FREIMANN @gmlaw.com. And you can see right behind you, the gmlaw.com.
Yeah.
As far as the direct dial, I'm at 720-370-1194. Just trying to make sure I got that right. 720-370-1194. And as you said before, I'm not in this to make long-term relationships. So people have questions, give me a call. I'm not going to start the clock. I want to see what you got going on out there. Happy to talk to you and see if we can figure something out. And would love to hear from all of the cannabis clients out there, and to see if they have any issues that we can help them with, and try to make sure that they're as productive and efficiently working as possible.
Michael, thank you so much. Everyone listening in, thank you so much. Another great speaker and good information coming your way in our next segment. Thank you for joining us.